everyone. Welcome to Crime in Court. This is the Menendez brothers' Path to Freedom, and we are going to be going over today the defense's reply to the motion to withdraw. So, obviously, if you're following this case, you probably already know that Nathan Hochman is the new DA, and he is trying to take away the request that was put in for resentencing by the previous DA, which there is no legal precedent for necessarily, unless there's like some kind of egregious thing wrong with, the evaluation. But that's not the case. And Nathan Hochman just likes to hear his own voice. So that's why he's contesting everything, I guess. And we read through his 88-page document full of lies. We are going to read through the defense's reply. It is only 31 pages, but 88 pages with exhibits. We're not going to read through all of the exhibits, but we'll kind of just, briefly go through them, just kind of look at them. And that will be the response to Nathan Hochman. And then Nathan Hochman gets to reply again in his team. So we'll go through that. And also new news. So this is also an update. I don't know if I said this in my other Path to Freedom video where we went over the motion to withdraw. But I think I don't know if I told you or not, but good news. Terry, Aunt Terry Baralt she's conscious now. She's not in intensive care anymore, but she's still in the hospital. She got to talk to Lyle and Erik from her hospital room, and she's doing a little bit better, but she still has a road ahead of her. And good news, she's okay. Also good news, they are going to they're complaining to the judge and enforcing Marcy's Law, which is a law to protect victims. So we will also read through that motion. They actually the family came together, filed a motion and said, "We're tired of this disrespect because of the hideous performance that they put on last week." Also, as you're listening to this, it's going to be Thursday, so the hearing for resentencing is taking place the day that this is premiering. So, just so you know, they're Thursday, the 17th and the 18th, right? No, am I? Yeah, correct. What are the dates? Yeah, 17th and 18th. So they will be um, in court. Probably not going to be a live stream or anything like that, like last time where Hochman, got to argue for 2+ hours or his deputy got to argue for 2+ hours about a bunch of lies when they were supposed to be arguing precedent for, being able to withdraw a resentencing motion. So let's get into it. Please hit the like button if you don't mind. And I'm going to get us started. So this is the defendant's reply to the people's motion to withdraw motion requesting 1172. That's the code, the statute, to recall to recall sentence and resentencing hearing. So there's a lot, as you can see. So they have a whole index. All right, introduction of politics and press conferences. In 1990, defendants Erik and Lyle Menendez were arrested and charged with special circumstance homicide, or M word that I can't say on YouTube, in the 1989 shooting deaths of their parents, Jose and Kitty Menendez. Erik and Lyle were 18 and 21 years old, respectively, at the time. There were two trials. At both trials, their defense was the same. They admitted shooting their parents, but the crime was manslaughter, not the M word, based on a lifetime of SA. In addition to their graphic testimony about SA, they offered compelling corroborative evidence to support the claim, including Diane Vandermolen, the cousin of the brother of the Menendez brothers, she says, when he was only 8 years old, Lyle pleaded for help from his teenage cousin Diane, who was visiting for the summer. 8-year-old Lyle asked if he could sleep in her bedroom. He said he was afraid of sleeping in his own room because he and his dad had been touching each other in his genital area. When Diane told Kitty about the essay, Kitty forcefully dragged Lyle away by the arm. She got mad at Diane. Diane was traumatized by it. And then Diane, like, still to this day, is traumatized by this occurrence that happened. And kind of put it out of her mind, thinking, well, I guess, maybe I took things out of context, maybe, because Kitty didn't care. But Kitty really didn't care. She said, no, Lyle's, not telling the truth. And she grabbed him by the arm and pulled him away. So. The hallway rule. Numerous family witnesses testified about the chilling hallway rule. The rule in the Menendez household enforced by Kitty Menendez. When Jose was in one of the bedrooms with either Erik or Lyle, no one was allowed to walk down the hallway past the bedroom doors. No one, not even to use the bathroom at the end of the hall. Andy Cano, who Nathan Hawkman basically just said was a liar, and the whole letter thing was a lie. Whatever. According to Erik and Lyle's cousin Andy Cano, when Erik was 12 or 13 years old, he swore his cousin Andy to secrecy and then asked if Andy's father ever massaged his quote unquote dick. 13-year-old Erik wanted to know if it was normal for fathers to use or to give such massages. Lyle's ninth grade essay. When he was in ninth grade, Lyle wrote an essay for school, but he picked a most unusual topic for the essay, at least for a ninth grade boy. He wrote an essay about a father put on death row for taking the life of a man who had just essayed his son. All right, so their first trial resulted in two juries hung almost evenly between convicting of the M word and the other M word, which is manslaughter, that I can say. At a second trial, many of the trial court's procedural and evidentiary rulings changed, and Erik and Lyle were convicted of the M word and sentenced to life without parole. So, first degree homicide is what they were charged with. And they did have the death penalty was on the table, but the jury chose life without parole. Since their arrest, 35 years have passed. The Soviet Union collapsed. Los Angeles has roiled by the Rodney King riots. Amazon started as a website that sold only books. I'm laughing because this is great. These are all things that have happened, like how we've progressed in the last 35 years, yet the DA's office hasn't. This is beautiful. Okay, so since their arrest, 35 years have passed. All these wonderful things have happened. Amazon started a website that sold only books. Germany was unified. Gay marriage was legalized, and Pluto was declared to be not a planet. The iPhone was introduced, and after a small company was founded in a garage in Menlo Park, California, the world learned to Google things rather than search them. The Twin Towers fell. The United States elected its first African American president, Barack Obama. The curse of the Bambino was broken when the Boston Red Sox ended their nearly century-long streak without a World Series win. Osama bin Laden was killed. The world went through the COVID crisis. 35 years have passed. The world has changed, and so have Erik and Lyle. That's powerful. Erik and Lyle are now 54 and 57 years old, respectively. On October 24th, 2024, and based largely on Erik and Lyle's extraordinary record of rehabilitation and service in that 35-year period, the district attorney filed a detailed 56-page people's motion requesting the recall of sentence and resentencing hearing, authored by Assistant District Attorneys Nancy Thaberge and Brock Lunsford. In the motion, remember those names because they come up. I know I've mentioned them before, but if you're just learning about this stuff, just keep those names in mind. All right, so in that motion, the district attorney also noted that number one, nearly 30 extended family members had attended a meeting with the district attorney's office to express their strong support of Eric and Lyle Menendez being resentenced and collectively confirm that the men were essayed by Jose when they were children. So it's not contested by the family at all that it took place, the essaying. But the DA's office is still trying to stick to their idea that it was all made up. Number two, a single family member opposed resentencing but declined to meet with the district attorney's office, instead making his views known through his attorney, Kathleen Katie's public statements and statements to the press. Remember that name too, because Kathleen Katie is then hired by Nathan Hawkman later after he takes office. And Nancy Thuburge and Brock Lunsford get demoted. Weeks after the filing, however, the sitting district attorney, George Gascon, was defeated in the November 5th, 2024 election by his opponent, Nathan Hawkman. Mr. Hawkman has now moved to withdraw the resentencing motion made by his former political opponent. But courts have placed limits on a district attorney's ability to withdraw a request for resentencing. Thus, in the controlling case of People versus Vassaw, which the people also quoted in their filing. So in the controlling case of People versus Vassaw, the Court of Appeal addressed the very situation we have here, an attempt by a newly elected district attorney to withdraw a pending request for resentencing made by his political opponent. Vassaw holds that a district attorney's office could not withdraw its recommendation due to a change in the political winds. Beautiful. That kind of is exactly what's happening here. Instead, the district attorney must identify a legitimate basis for withdrawing the resentencing request. So the question here is whether the record shows the decision to withdraw the request for resentencing motion was based on a legitimate reason or instead a change in the political winds. And we read through his motion, his 88-page motion, and I didn't see one legitimate reason why the motion should be withdrawn. As more fully discussed below, and to his credit, the newly elected district attorney certainly said all the right things in press interview after interview, both print media and televised. Mr. Hawkman repeated the refrain that before making any decision in the Menendez brothers case, he would have to do the hard work of coming up to speed in the case, read the many thousands of pages of trial transcripts, read the confidential prison files, and speak to the victims' family members. But the newly elected district attorney's actions told something of a different story. As also discussed more fully below, within days of taking office and well before he had even begun the hard work of coming up to speed on the case, the newly elected district attorney fired one of the lawyers who filed the original resentencing motion, transferred the other, and appointed Kathy Katie, the private attorney representing the lone family member opposed to resentencing, as head of the district attorney's Department of Victim Services. So he hired Kathy Katie, who was a private attorney for Milton Anderson, who was opposing the brothers getting released or resentenced. By all appearances, and if that's not a conflict of interest, I don't know what is. By all appearances, although the hard work of coming up to speed in the Menendez case had not yet begun, hard decisions as to the personnel involved and direction of the Menendez case seemed already to have been made. That's an excellent, excellent point. How are you doing the hard work if you're getting rid of the people who did the hard work in the beginning? You're getting rid of the people who are knowledgeable about this case, who did the resentencing request. But there were decisions based on proper legitimate reasons or simply a change in the political winds. On February 21st, 2025, the new district attorney held a press conference to announce that he would be opposing Eric and Lyle's pending habeas petition. On March 10th, 2025, he held a second press conference to announce that he would be moving to withdraw the prior district attorney's request for resentencing. Several days after that, he did a national interview with ABC reporter Matt Gutman about the Menendez case. In the March 10th, 2025 motion to withdraw, the district attorney properly recognized that under VASA, withdrawal may not be based on a change in the political winds. So he even brought it up in his motion because I highlighted that point and I was like, yeah, exactly. That's what you're doing right now. But the motion to withdraw was not political. Instead, it was based on the new district attorney's personal participation in a thorough and complete review of the original request for resentencing. According to the written motion, withdrawal is proper because the original resentencing request, number one, failed to consider whether Eric and Lyle had complete insight and acceptance of responsibility into the crime, and two, missed significant in custody rule violations. This reply follows. As discussed below, the motion to withdraw contains serious factual and legal errors. The suggestion that there is a lack of insight here justifying withdrawal of request to resentence ignores Eric and Lyle's consistent taking of responsibility and expressions of remorse over decades in prison. The facts of the preliminary case on which the current district attorney himself relies, the Suran case, and relevant case law. And in arguing that the original request to recall the sentence somehow failed to consider relevant violations of prison rules, the district attorney improperly relies either on allegations which, after an appeal and a hearing, the CDCR itself elected not to punish, or on such utterly innocuous conduct as speaking too long on the telephone more than 2 decades ago. Like I said, every violation that they came up with was in like the 90s in their motion. Improperly trying to get a new pair of sneakers 15 years ago, or possession of a typewriter and stationery 27 years ago. How'd you get a typewriter into your prison cell? That's pretty impressive. Minor incidents, which are not only decades old, but which quite literally have nothing to do with public safety. Exactly. Nothing to do with safety. Okay, you had a cell phone in prison? Who cares? It has nothing to do with whether they're going to reoffend when they get out. As reliance on these types of incidents show, the district attorney's newly minted concerns make weight. They do not justify withdrawal of the previously filed motion to recall the sentence. But before discussing whether under VASA these new justifications permit withdrawal of the original resentencing request, there is a fundamental irony in the district attorney's position which deserves comment. As noted, the district attorney now alleges that Eric and Lyle have shown an insufficient insight into the crime. In considering this claim, it is important to recall that although there was much the parties disagreed about through the course of years of litigation and two separate trials, until now there was at least one point on which both sides could completely agree. Both the prosecution and the defense recognized that the question of SA was the centerpiece of the whole case. Every party in court knew this, full stop. After all, Eric and Lyle had admitted to shooting their parents. Thus, the only question for jurors was their mental state at the time, which has to do with the years and years and years of severe abuse that they had to endure. And the question of whether Eric and Lyle had been SA'd since they were children was central to the state of mind inquiry. The trial prosecutor was certainly aware of how critical the question of SA was to the case. That is why, during closing arguments at the second trial, he argued that the abuse allegations in the case were a total fabrication. There was no way of corroborating the allegations. The abuse never happened. There was no corroboration of sexual abuse, and the allegation of physical and SA are not corroborated. Jose Menendez was restrained and forgi who says he was restrained and forgiving? Well, David Kahn says that, and that's ridiculous. And not the kind of man who would be abusing his sons. Okay. Okay. There would, of course, be no reason to make these arguments if SA had not been at the center of the case. Exactly. Just like the prosecutor, the respective defense lawyers for Erik and Lyle were equally aware of how important the question of SA was to the case. In contrast to the prosecutor, however, defense counsel urged jurors to find that the SA occurred. By way of example only, Erik's counsel argued in closing that Jose Menendez essayed Erik from the time that he was 6 until the time he was 18. The essay was why you cannot convict my client of homicide. Andy Cano's testimony confirmed the essay. The hallway rule testimony confirmed the essay, and Erik was essayed beginning at the age of 6. Similarly, also by way of example only, Lyle's counsel argued that Lyle was also essayed when he was a child. The essay explained his fear. Lyle wanted to avoid referencing the essay, and the shooting occurred because Jose was essaying his son. I mean, it's all because, it's the underlying reason of everything. And they just eloquently put that or lay that out. So, in his rebuttal argument, the prosecutor recognized yet again that the question of essay was the linchpin of the defense. Although he continued to disagree with the defense as to whether the abuse occurred, the trial prosecutor recognized not only that the allegations in the case are premised upon the essay, but the essay was what the case was all about. This was inevitable. It's inevitable from the type of defense that was chosen in the case because it was, as I indicated to you, an abuse excuse. This was clear from day one that this was what the case is all about. But now, more than 3 decades later, the new district attorney who has done the hard work of coming up, I like how he keeps quoting hard work. Like quotes like he's really doing any kind of work. So the district attorney who has done the hard work of coming up to speed on the case tells a very different story. Ignoring the positions taken both by defense counsel and the trial prosecutors themselves, the new district attorney observes that jurors were never asked to render a verdict on SA and maintains that the SA was not their defense at trial. The irony, of course, is that it is the same DA who alleges that it is Erik and Lyle who lack proper insight. Yeah, that's pretty funny. That he doesn't even understand that the whole trial revolves around the essay, yet it's the brothers who have no insight into this case. The merits of the insight argument will be discussed below, but it is time to be candid. The district attorney may, in its wisdom, maintain that 8-year-old Lyle was lying to his cousin Diane when he told her his father was essaying him. He may maintain that numerous family witnesses were lying about the strict hallway rule enforced in the Menendez home. He may maintain that cousin Andy was lying when he testified that 13-year-old Erik asked him whether it was normal for fathers to massage their son's penis. He may maintain there is nothing unusual about a ninth-grade boy writing an essay about a father put on death row for taking the life of a man who molested his son. That is the DA's prerogative in an adversary system. But there should be, indeed, on this record, there can be no dispute as to whether SA was the central question in this case. Of course it was. As the trial prosecutor conceded at trial, essay was what this case was all about. So, yeah, you can't have it one way and then argue it a different way. You can't have it both ways. Statement of fact. The original motion to recall the resentence, or the sentence, I read it right the first time. All right. The district attorney's original motion to recall the sentence was prepared by Assistant District Attorneys Nancy Theberge and Brock Lunsford. In that motion, they properly noted that in Section 1172.1, the legislature set forth guidelines for courts to consider in the resentencing calculus. These include 1. The disciplinary record and record of rehabilitation of the defendant while incarcerated, which Nathan Hochman didn't talk about basically at all, and 2. Whether the defendant was a youth as defined under the subdivision at the time of the commission of the offense, and they were, and whether those circumstances were a contributing factor in the commission of the offense. We have a footnote here. The section defines youth as a person under 26 years of age at the time of the offense. 3. Whether age and time served have reduced the defendant's risk for future violence. He never once addressed that. And 4. Whether circumstances have changed since the original sentencing so that continued incarceration is no longer in the interest of justice. Evidence of changed circumstances includes evidence that undermines the integrity of the underlying conviction or sentence. Finally, Subdivision A5 mandates that resentencing courts consider whether the defendant was a victim of SA. The court shall consider if the defendant has experienced psychological, physical, or childhood trauma, including but not limited to abuse, neglect, exploitation, or sexual violence prior to or at the time of the commission of the offense. I would say that they experienced all of those things except maybe exploitation, but kind of maybe so because I mean the parents exploited them for their own image. So in a way they were exploited by their own parents. In the original request for resentencing analyzed these factors in some detail. Thus, in a 28-page section of the request, the district attorney properly focused on the remarkable evidence of rehabilitation for both Erik and Lyle. There is no need to repeat that evidence here. Suffice it to say that after reviewing more than 30 years of custodial records, the district attorney noted achievements in education, participation in and founding of numerous self-help and recovery programs and workshops, laudatory reports from correctional staff, decades of exceptional work history, and at the end of the day, felony risk assessment scores of 1, the lowest score possible, and raw security risk scores of 0, the lowest score possible. All accomplished when defendants were under a sentence of life without the possibility of parole, with no hope that such conduct could somehow inure to their benefit. So they had no they did all these good things for no other reason than to do good. I mean, they weren't doing it just for their own, to make themselves look good. As the district attorney properly concluded after reviewing Erik's in-prison conduct, Erik has proven himself to be an incredible asset to his prison community. He has excelled in the work environment, and he has been highly productive in the learning environment. He has been a leader and a facilitator in prison programming. The district attorney's conclusion was similar as to Lyle. Lyle has established an overwhelming record of rehabilitation. It is important to note that Lyle Menendez has not been involved in a single fight in the 30 years he has been incarcerated, and CDCR had to move him into a different prison yard in 1997 because he wouldn't fight back when he was attacked. Lyle Menendez has excelled in the academic environment. He graduated from UC Irvine, was on the dean's list every semester, and was nominated for the National Merit Society in 2023. Based on the programs he participated in and founded, he has proven himself to be an incredible asset to the prison community. He has created 4 new programs within the prison system to assist and better his fellow inmates' quality of life. The district attorney also discussed the 2 very different age related factors a sentencing court must consider under the subdivision: age at the time of the crime, age at the time of resentencing. He noted not only that Eric and Lyle were 18 and 21 at the time of the crime respectively, but the changes in our current understanding of brain development based on decades of scientific research since this sentence was imposed. Based on these factors, their youth at the time of the crime is a highly mitigating factor, the import of which was not fully understood or considered at the time of the initial sentencing. At the time, we didn't know that a brain under the age of 26 is not fully developed and doesn't understand the ramifications of what they do. And now we know. So now we can do better. And on the other side of the age calculus, because Eric and Lyle are now 54 and 57 respectively, both have a reduced risk for future violence. As noted above, the district attorney recognized that the subdivision also requires the sentencing court to consider whether defendants were essayed as children. Relying primarily on the original probation report, the district attorney concluded that childhood abuse and trauma incurred by both defendants in this case is sufficient to invoke court consideration under 1170 subdivision and a bunch of subdivisions. The election and the hard work of coming up to speed on the case. And again, they keep quoting hard work because they're not doing any work other than a PR tour. George Gascon was the elected district attorney when the request to resentence was filed. In the election of November 5th, 2024, what did I just say? 19. Hold on one second. Okay, that confused me. I heard a dog bark outside and I thought it was my dog. It's not. Um, sorry. Okay. In the election of November 5th, 2024, I don't know why I said 19 at some point there, Nathan Hochman defeated Mr. Gascon and became the new district attorney. On November 6th, the day after the election, Mr. Hochman told KTLA Channel 5 that he would have to do the hard work of receiving thousands of pages of confidential prison files, thousands of trial transcripts from months long trials, and you have to speak to prosecutors, law enforcement, defense counsel, and the victims' families. On November 15th, during a televised interview with Channel 12 Action News, Mr. Hochman repeated that before deciding whether to support the pending resentencing motion, he would have to do the hard work to make the decision. And this would include reviewing thousands of pages of confidential prison records, and I don't have access to at this point, and thousands of pages of trial transcripts from months long trials. You have to review thoroughly the facts of the law. The admirable mantra of doing the hard work before making a decision was something that was repeated again and again. We're going to do a thorough review of the facts and the law. I will put the hard work in to look at the facts and the law. That was on News Nation. He says, I'm not going to speculate. I'm going to do the work. I'm going to do the full analysis. Another News Nation interview. Next section. Within days of his election and before doing the hard work to come up to speed on the case, the newly elected district attorney fires Nancy Theberge, transfers Brock Lunsford, and appoints Kathleen Cady as head of victim services. As noted above, the district attorney's original request for resentencing was signed by Nancy Theberge and Brock Lunsford. It turns out that signing the resentencing request would effectively end their respective careers in the DA's office, because signing that resentencing request, which is just something they are supposed to do in the normal process of their jobs, um, ending their careers because Nathan Hochman didn't like it. Mr. Hochman was sworn into the role as district attorney on December 3rd, 2024. Staff changes were quick. Only 3 days later, Ms. TheBurge was fired from the district attorney's office entirely, transferred to the county alternate public defender's office. Ms. Lunsford or Mr. Lunsford was exiled um, after that. Although he had spent 24 years as a lawyer with the district attorney's office, he had never received a poor performance review and was a supervisor in the office. By December 14th, he had been stripped of all of his supervisory responsibilities and transferred to the Norwalk courthouse as a calendar attorney. The transfer to Norwalk appears to be an example of what is known as a freeway therapy, which has a long history in Los Angeles County, recognized in both cases and media. It's a form of punishment involving assignments which involve a long commute. Wow. Um, and then there's a bunch of case law that they cite here. Attorneys in the district attorney's office can be denied promotions, banished to far-flung offices in what is known as freeway therapy, stripped of important cases, or relegated to mundane, demoralizing duties. Wow. Okay. Um, that's sad. That sucks because of political reasons. They don't believe you. So they send you off to a faraway office where you're out of sight, out of mind, and you can't be a nuisance to anybody, pretty much. Like, get out of here. It's ridiculous. I hate Nathan Hogman so much. 10 days after he was sworn in as district attorney in a December 13th interview with Deadline magazine, Mr. Hochman was asked about the Menendez brothers case. Mr. Hochman said that he had just begun reviewing the many thousands of pages of material in the case and was not yet up to speed. Given that he had just been sworn in, this response was entirely fair. But although he had just begun to review material in the case, Mr. Hochman had already fired Ms. TheBurge and transferred Mr. Lunsford. Similarly, in that same interview, and again before he had come up to speed on the case, Mr. Hochman publicly announced his view that any suggestion the Menendez brothers' trial centered on the question of childhood essay was absolutely wrong. And he admitted that although he remained willing to speak with counsel for Erik and Lyle, he had already spoken to Kathleen Cady, the lawyer for the only family member opposing the resentencing. Indeed, he had. On December 24th, 2024, and as one of his first appointments after winning the election, Mr. Hochman appointed Ms. Cady as director of the District Attorney's Department of Victim Services, effective January 6th of this year. On March 10th of this year, the district attorney moved to withdraw the request for resentencing. The 28-page section of the district attorney's original request for resentencing, discussing rehabilitation, educational programming, and work-related achievements during Erik and Lyle's more than 30 years in prison, is covered in 3 sentences. 3 sentences on page 83 of the motion to withdraw. I noticed that he didn't talk about that at all. That he didn't talk about any of their rehabilitation or what they've done while in prison. And although the motion to withdraw expresses concern about whether 54-year-old Erik and 57-year-old Lyle now pose an unreasonable risk of danger to the community, the motion makes no reference to the fact that both Erik and Lyle have the lowest possible felony risk assessment scores. They each earned a score of 1, and the lowest possible raw security risk scores. They each scored a 0. All right, here's the argument. The motion to withdraw should be denied because the newly minted reasons now offered to justify withdrawing the request for resentencing are either patently meritless or were properly considered and rejected by the prior district attorney, or both. As noted above, and we know that the judge did deny the people's request to withdraw, so It's good that we know that now and we're not super, super mad as opposed to being really, really mad. All right. So, as noted above, the new district attorney correctly recognizes that under Vassau, withdrawal it may not be based on a change in the political winds. Motion to withdraw, page 69. According to the new district attorney, his personal participation is a thorough and complete review revealed legitimate non political reasons for withdrawing the resentencing request. It turns out prior district attorney blundered and missed two very key points, which are addressed in sections 5 and 6 of the motion to withdraw. Erik and Lyle will discuss each of the newly asserted reasons for withdrawing the motion to resentence. The asserted lack of insight into the crime. In Section 5 of the motion to withdraw, the new district attorney alleges that the initial resentencing motion was flawed because the motion failed to consider Erik and Lyle's lack of complete insight into the acceptance of responsibility for their crimes. Analogizing to parole suitability, he notes the relationship between the defendant's insight into his or her crime of commitment and whether the defendant poses a current danger to society. The district attorney repeatedly argues that the governor's decision to deny parole to Suran provides a useful template for analyzing the relationship between the defendant's insight into and the attitude towards his commitment offense and the question of whether the defendant is dangerous. The district attorney explains the relevance of the Sirhan case to this case. The comparisons between Suran and the Menendez brothers' cases are instructive for the court in ascertaining whether the failure of the Menendez brothers to exhibit full insight into their crimes overcomes various pro-resentencing factors. The parties have some common ground in this issue. Erik and Lyle agree that at the Second District Court of Appeal, that, as the Second District Court of Appeal has recognized, a defendant's lack of insight into his crime and failure to take responsibility for it may constitute some evidence that he currently poses an unreasonable danger to society. And they agree that the Suran case relied on again and again by the new district attorney is a useful case for analyzing the relationship between insight, taking responsibility, and current dangerousness. But that is where the common ground ends. As discussed below, the district attorney's insight analysis has not only missed the whole point of Governor Newsom's approach in the Suran's case, but ignores decades of published case law. The Suran's decision. The decision to withdraw filed by the new district attorney is accompanied by 19 exhibits. Yet, although the district attorney repeatedly relies on the governor's decision to deny parole in the Suran case, he does not provide a copy of that decision as an exhibit for the court's review. That omission is remedied here. As an examination of that decision shows, the new district attorney's discussion of the Suran case is curiously incomplete. In fact, as the text of the governor's actual decision shows, and contrary to the district attorney's position with respect to insight into the crime and current dangerousness, the Suran case is the polar opposite of this case. Suran was convicted of homicide in the 1968 assassination of Robert Kennedy. After his arrest, he admitted to taking Robert Kennedy's life to the police. At his trial in 1969, he admitted to it both in his testimony and in outbursts during trial. In parole board hearings in 1979 and 85, he admitted it again. But then, as Governor Newsom noted in ultimately denying parole, Sirhan began a years-long period of increasing denials. So there's the difference. He started denying it at some point, ultimately resulting in a claim of complete innocence of the crime. So it's he admitted it up until about 85 and then decided, yeah, no, I didn't do it. So what's the parole board supposed to do at that point? Thus, in a 1989 parole board hearing, Sirhan said that he could no longer recall the details of the crimes. In a 1990 hearing, he repeated that he had no memory of the shooting. In 1997, Sirhan said he did not commit the crime and was innocent. In 2001, Sirhan said he doubted that he committed the crime. At a 2011 parole hearing, Sirhan said that he could not recall using his gun. At a 2016 parole hearing, he said he was innocent and legally speaking, I'm not guilty of anything. Finally, in 2021, Sirhan told a board psychologist that he was innocent of the crime. In relying on the Sirhan case, the new district attorney does not discuss any of these facts. He leaves out a lot of the facts that are inconvenient to the point he's trying to make. I've noticed. Instead, the district attorney provides Exhibit 18, a carefully curated chart regarding the Sirhan case, which omits any reference to all, or it omits any reference at all to Sirhan's near quarter century history of claiming innocence. It doesn't mention it at all. But in denying parole, Governor Newsom did not ignore this history. Instead, he properly noted Mr. Sirhan's implausible and unsupported denials of responsibility and included that Sirhan's discussions of his crimes suggested that he was still a threat to public safety. The governor also noted Sirhan's connections to political violence on his behalf. When Sirhan was told about terrorists who kidnapped 10 hostages to demand his release from prison and ultimately took the lives of those 3 hostages, Sirhan's reaction was to laughingly dismiss the incident. Although the new district attorney repeatedly relies on the Sirhan case in its motion to withdraw, these facts and the governor's rationale seem simply to be missed by the DA. Erik and Lyle quite agree with the district attorney that the Sirhan case properly illustrates the relationship between a defendant's insight into his crime and whether the defendant is currently dangerous. Despite initially admitting to shooting and over the course of nearly a quarter century from 97 through to 2021, Sirhan not only refused to accept any responsibility for the shooting, but he went even further, claiming he did not commit the crime, he was innocent, and he was not guilty of anything, and he was innocent of the crime. Those are his words quoted verbatim. And he then laughed at the homicide of 3 innocent people kidnapped by terrorists advocating for his release. So these people were advocating for him and they lost their lives in the process and he laughed. What a guy. Swell. He was probably MK Ultra, but that's a whole nother rabbit hole I don't want to get into. On this record, the governor properly concluded that Sirhan still posed a risk to public safety. But this case stands in sharp contrast to Sirhan's case. It is certainly true that here, Erik and Lyle, when they were 18 and 21 years old, respectively, lied to police after the shooting in an effort to avoid responsibility for the shooting of their parents. At both trials, however, they admitted to the shooting, contending that because of the lifetime of SA, the crime was not homicide. It was not the other M word, but manslaughter. And from the day that they were convicted, and as they were matured in and as they matured in prison over the years since trial, in both court filings and public interviews, they have both taken responsibility for the shooting and expressed deep remorse. What we did was awful, and I wish we could go back. That was an interview with Barbara Walters in 1996. There's not a day that goes by that I don't think about what happened, and I wish I could take that moment back. I am the kid that did KILL his parents, and no river of tears has changed that, and no amount of regret has changed it. These are all quotes, by the way, if you're not looking at the screen. And I'm not going to quote them all, but they're coming from different interviews, obviously. Larry King, Today Show, ABC News. I completely regret I don't think I want in any way looking back to be the judge and jury of my father's actions or my mother's. It's really a regret every day, but at the same time, you really, I can't escape what happened anymore than I can escape sort of the memories of what happened to me. Larry King says, "Do you ever regret what you did?" And Erik says, "Immensely, so immensely so. Not a day goes by when I don't wish that I could undo this or I could bring them back. It's my unending regret, and in a sense, it's my real prison." And according to Correctional Officer Kay Meyer, "I have had conversations over the years with Mr. Lyle Menendez in which the crime for which he is incarcerated came up. I found him to be remorseful and thoughtful about it." In short, the new district attorney is correct that the Sirhan case shows how a denial of responsibility can relate to current dangerousness. But, as the governor noted, and precisely because Sirhan repeatedly denied responsibility for the shooting, the case has no application here and cannot reasonably serve as the basis to withdraw the properly filed resentencing motion. The district attorney's insightful analysis, he quotes that because it's not so insightful, but the district attorney's insightful analysis not only ignores the facts of the Surin case, but substantial case law as well. There's a lot of snark in this, and I like it. Not surprisingly, case law confirms the relationship between taking responsibility for the crime and current dangerousness on which Governor Newsom so directly focused in the Sirhan case. There, the defendant was charged with homicide in the shooting death of his former girlfriend. He admitted the shooting. He claimed he was not guilty of homicide, just manslaughter on a negligent homicide theory. The jury rejected the claim and convicted of the M word. During his years in prison, defendant was a model prisoner. He obtained job skills, he engaged in programming with laudatory reports, and he took college courses. At all points during his incarceration, although defendant took full responsibility for the actual shooting, he continued to maintain he was guilty only of manslaughter, not the other M word. Ultimately, defendant was denied parole because of a lack of insight into the crime due to his continued insistence that the crime was manslaughter and not the other M word. The appellate court granted habeas relief, noting that in light of many factors favoring parole, defendant's belief that the homicide was a manslaughter simply does not support the conclusion that he lacked insight into the crime and would therefore pose a current danger to the community. That's a great uh, example of case law that helps kind of destroy uh, Nathan Hockman's argument there about, well, they're not taking full responsibility. Similarities between the case and Palermo, are remarkable. Like Palermo, Eric and Lyle were charged with homicide. Like Palermo, they admitted the shooting at trial, but contended the offense should be manslaughter. Like Palermo, they were convicted of the other M word. Like Palermo, they both have remarkable in custody records involving education, work, and programming. Like Palermo, they continue to accept responsibility for the shooting and express remorse. And like Palermo, they continue to maintain that the offense should have been manslaughter, not the other M word. As Palermo recognizes, in this identical situation, defendants have not expressed some kind of insufficient insight to the crime. Where an inmate's version of the offense is physically impossible or highly implausible on its face, continued adherence to that theory may support an inference of current dangerousness. Whoops, sorry. I didn't mean to show my home screen there. Um, Petitioner entered wife's home uninvited, wearing rubber gloves, carrying a loaded gun, a wrench, and industrial acid, shot the wife in the head, bludgeoned her male companion, and later claimed throughout parole proceedings that he simply wanted to show his new gun to his estranged wife and that the gloves, wrench, and industrial acid were brought for household chores. Uh-huh. Yeah, that I buy that. Sure. And held that the defendant's attitude towards the offense supported an inference of current dangerousness. Yeah, I would say so. But where an inmate's version of an offense is neither impossible nor strains credulity, it does not justify a finding that he is currently dangerous. The objective record of jury deliberations over two separate trials in this case belies any suggestion that the manslaughter version of the offense, based on a lifetime of uh, sexual and physical abuse, is either physically impossible or highly implausible. After all, the two juries to hear this case at the first trial split almost evenly between manslaughter and the other M word. And even after extremely probative evidence was excluded at the second trial, the jury deliberated 35 hours before two jurors were removed and another 20 hours thereafter. I wonder what that was about. From a rhetorical perspective, Erik and Lyle certainly understand the district attorney's continued focus on falsehoods they told in the aftermath of the crime and even during their 1993 and 1996 trials. But the case law makes clear that this conduct is of relatively little relevance to the question of current dangerousness. And he spent 80 some pages talking about all the lies that don't have any that have no relevance to their current dangerousness. Erik was 18 years old at the time of the crime. Lyle was 21. They lied and they tried to fabricate evidence. As our Supreme Court has long recognized, however, the passage of time is highly probative to the determination of current dangerousness, and relevance on outdated information will not justify a finding of dangerousness. The Second District Court of Appeal has reached the identical conclusion. In fact, or the fact of the matter is, that more than 3 decades have passed since the pretrial and trial events on which the district attorney now places so much reliance. This is precisely why the fact that an immature defendant may lie to police in the aftermath of a crime, or hide evidence, or even testify falsely at trial, does not indicate that they lack insight or will be a danger to society decades and decades later when they mature. 20-year-old defendant convicted of first-degree homicide lied to police after the crime, testified to a false alibi at trial, suborned perjury from an alibi witness, held parole proper after 35 years of a positive in custody conduct. So even this guy lied about his alibi. He got people to lie for him on the witness stand, and he still got parole. So what is Nathan Hockman's panties in a wad for? 21-year-old defendant charged with the homicide of his ex-girlfriend. Defendant lied to his sister and police and removed evidence from the crime scene to try and cover up the crime. He was held parole proper after 20 years of positive in custody conduct. So these people are doing less time than Lyle and Erik, and they're doing a similar, having a similar situation where they're lying in the beginning to cover up their crime. Defendant charged with the homicide of his ex-girlfriend. Defendant lies to police about his role and falsely accused a third party, held parole proper after 25 years of positive in custody conduct. So 20 years, 25 years. This other person was 34 years. So again, they're being held for less time than the brothers at this point. These cases did not break new law. They simply reflect the common sense observations of both the United States and California Supreme Courts that the distinctive attributes of youth include a lack of maturity and an underdeveloped sense of responsibility and an inability to extricate themselves from horrific crime producing settings. So, it is here. Erik and Lyle were 18 and 21 when they committed the crime. They are now 54 and 57 years old, and in the multiple decades since the crime, They have continued to admit their role in the shooting, express remorse for the harm they caused, and make extraordinary strides in education, programming, and rehabilitation while in prison. And there may be a second irony at play here. In his inaugural speech as district attorney, here comes some more snark, Mr. Hockman noted that his office would not ignore victims, but would instead serve as a champion for the voices of crime victims. We're going to make sure that victims understand that the DA's office is going to resume a role that it has had for decades as a champion of victims out there in our society. I don't believe any of that. As the district attorney's original request for resentencing makes clear, and as the new district attorney's motion to withdraw does not dispute, in October 2024, nearly 30 extended family members attended a meeting with the district attorney's office to express their strong support of Erik and Lyle Menendez being resentenced and collectively confirmed that the men were essayed by Jose Menendez and they were young children when they were young children. Instead of championing for the families, victims here, the motion to withdraw abandons them completely. So not only are, Eric and Lyle victims of their parents and the system, but the victim, the family members of the Menendez brothers are also victims, and they're being re-victimized by this and re-traumatized by this DA. Eric and Lyle have now served 35 years in custody. The new district attorney's position that withdrawal of request for resentencing is justified due to insufficient insight into the crime ignores case law, the facts of the main authority in which the district attorney relies, and Eric and Lyle's repeated taking of responsibility for the shooting and expressions of remorse. It places near dispositive reliance on outdated, decades old actions of an 18 and 21-year-old. Actions that have been eclipsed by extraordinary in custody rehabilitation efforts. And it ignores the pleas of 30 of the victims' family members, rendering hollow the new district attorney's own claim that his office will be the champion of victims out there in our society. The motion to withdraw the request for resentence should be denied. The district attorney accurately observes that a defendant's inadequate insight into a commitment crime may be relevant to whether the defendant poses a current danger to society. But it seems odd to express concern about current dangerousness as a reason to withdraw the resentencing request, but not discuss in some detail or at least mention the fact that according to the CDCR itself, both Eric and Lyle have felony risk assessment scores of 1 and for a decade have had a raw security risk score of 0. Yet, aside from a passing reference to the fact that predictive scores were detailed in the original resentencing request, the current motion says nothing about the validated risk assessment scores. He says nothing to back up his claims that these brothers shouldn't be released because they're dangerous. He has no evidence to back that up and nothing to assert it in his motion. The asserted inadequate description of the prison files. Section 6 of the motion to withdraw offers a second reason why withdrawal of the motion for resentencing is proper. There, the district attorney argues that the request was separately flawed because it failed to sufficiently detail information contained within each inmate's prison files. The new district attorney accurately notes that the original resentencing request advised the court that 1. Eric's prison file showed 8 rule violations, and 2. Lyle's prison file showed 5 such violations. According to the motion to withdraw, however, Eric has been cited at least 13 times for violating prison rules, and Lyle was cited for violating the prison rules, including failures to report for work, at least 19 times. The district attorney now argues that this inexplicable and alarming undercount justifies withdrawal of the resentencing motion. It does nothing of the sort. As discussed below, this suggestion ignores the prison violation classification system and conflates serious rule violations, which may be relevant to an inquiry into current dangerousness with outdated technical violations that have nothing to do with the import inquiry. Moreover, as also discussed below, the current district attorney has relied on allegations which the prison itself investigated and elected not to punish after neither eyewitnesses nor video footage supported them. So the brothers weren't punished for these other things. So they weren't part of their record, like it wasn't even something. You're trying to conflate the fact that these other issues might have not been added, but they weren't added maybe because they weren't relevant, they weren't necessary. The prison discipline system. Title 15 of the California Code of Regulations governs the administration of prisons, including prisoner misconduct, which generally fall into three categories. The most serious rule violations, known as Rule Violation Reports, RVRs, or 115s, are defined and governed by CCR, the California Code of Regulations, Title 15, Section 3323. These rule violations are subcategorized by degrees of seriousness into Divisions A through Division F. Division A represents the most serious violations, including the M word, the R word, or escape and result in forfeiting between 181 and 360 days of credit against a release date, possible placement in a secured housing unit, points added to classification scores used to determine housing, and possible criminal prosecution. Division F represents the least serious violations, including such as gambling or refusal to work, and result in forfeiting up to 30 days of credit against a release date. The second category of misconduct, administrative violations, are defined and governed by CCR Title 15, Section 3314. Although administrative violations are also reported in an RVR, administrative violations reflect less serious violations of CDCR rules and do not result in current forfeiture, shoe placement, or points added to the inmate's classification score. An administrative misconduct finding may result in loss of privileges, including access to yard time or other activities. Example of administrative misconduct include missing a work assignment, use of vulgar language, and failure to comply with grooming standards. So, not really a huge violation. The third and least serious category of misconduct is reflected in counseling chronos, reflected in the CCR Title 15, Section 3312. Counseling chronos are sometimes referred to as 128s because these rule violations are documented on CDCR Form 128. A counseling chrono can be used to record any misconduct that does not amount to a serious rule violation or administrative misconduct. The chrono merely records that the misbehavior was observed and reported to the inmate. There was no disciplinary consequences from a counseling chrono. Examples of misconduct warranting a counseling chrono include taking too much food from a cafeteria, taking too long to shower, or altering prison garments. The California Supreme Court has taken cognizance of these distinctions in the parole context and cautioned against denying parole based on administrative misconduct or counseling chronos. Defendant convicted of premeditated homicide, parole board finds her a danger to public safety in part by relying on 8 administrative misconduct RVRs and counseling chronos for being late to work. Held these administrative violations and counseling chronos did not support a conclusion that petitioner poses a threat to public safety. As one appellate court has put it, prison discipline, like any other parole unsuitability factor, supports a denial of parole only if it's rationally indicative of the inmate's current dangerousness. Not every breach of prison rules provides rational support for finding of unsuitability. So, not every little thing in prison amounts to discipline or being, putting it on their record or making them dangerous. So Huckman's arguments are ridiculous anyways, but like he really needs to lay this out that, having a cell phone makes you dangerous, really? That's your argument? He got caught with a cell phone. Eric's prison disciplinary history. The current motion to withdraw focuses on the number of violations without examining which, if any, are serious and which, if any, are recent enough to be relevant to accessing current dangerousness. As to Eric, it alleges that Eric has 5 rule violations which were not discussed in the original request for resentencing. But the district attorney does not discuss what these 5 additional violations are or when they occurred, with good reason. 4 of these violations are either counseling chronos or administrative misconduct only, and none have occurred within the past 2 decades. 3 occurred 28 years ago in 1997. 1. A 1997 counseling chrono for possessing a floppy disk with personal letters on it that officers found did not contain anything that would jeopardize the safety of security of the institution. 2. A March 1997 counseling chrono for improperly kissing and hugging his female visitor. Number 3. A May 1997 administrative misconduct for again improperly kissing and hugging his fiancee during a visit. The fourth is more than 20 years old, a March 2005 counseling chrono for talking too long on the telephone. The district attorney cannot plausibly maintain that any of these minor violations are sufficient to show current dangerousness and justify withdrawing the resentencing motion. In addition to these 4 technical rule violations, the district attorney calls the court's attention to a 26-year-old RVR based on an incident occurring on January 17, 1999. Prison guard Cousins alleged that Eric had a female visitor, and during an argument, Eric pulled her out of her chair, pushed her, and when she walked away, grabbed her by the back of the neck and pulled her back. Eric denied this conduct, alleging that Cousins exaggerated. A hearing was held. The district attorney's own documents show that Officer Hanley and Rocha were in the visiting room, but would not corroborate Cousins stating that they did not see the incident. 3 inmates testified. Inmate Cruz saw no problem between Menendez and his visitor. Inmate Sims saw them in a disagreement but no physical contact. Inmate Perry never saw him push or pull her. For her part, the visitor herself, Ms. Sackerman, spoke with officers. Eric lifted her out of the chair, as if leading her somewhere, but did not, as Cousins reported, pull or drag her out of the chair. She did not, as Cousins reported, walk away from him. And Eric did not, as Cousins reported, put his hand on her. Hearing Officer Kane then reviewed video footage with Cousins. In dramatic fashion, the district attorney now claims that the footage demonstrated that Eric was the one lying. It does not. In fact, after reviewing the video footage, Cousin himself admitted he could not identify on the video either time when Eric grabbed his visitor by the neck or pulled her back. Although neither his fellow guards, the inmates, Ms. Sackerman herself, nor the video footage corroborated him, Cousins had a ready explanation blaming this on the angle of the camera and the clarity, and the fact that a third camera had faulty wiring. And although the district attorney quotes Officer Kane's conclusion that Eric employed aggressive contact, Ms. Sackerman with Ms. Sackman, he neglected to include the very next sentence in the report. I cannot determine if you grabbed your visitor by the neck or not. Perhaps even more unsettling, the district attorney does not inform the court that after the videotape was viewed, Eric's appeal was partially granted. Indeed, it was. As expert witness Subia explains, Eric's file reflects that he suffered no consequences or credits lost in relation to this incident. If the violation was sustained, his file would reflect lost credits. Furthermore, there were no additional documents related to the incident in Eric's central file because, consistent with CDCR practices and regulations, documents related to a violation that has been dismissed are either removed from the inmate's record or updated reflecting the dismissal. So, and he had no lost credits. So he wasn't found guilty in this situation. Yet Hockman lies and says that the video proves Erik was lying when it clearly doesn't. So I was waiting for an explanation to that, and I'm glad we got one that made sense. It makes sense to me. Moving on to Lyle's prison disciplinary history. As to Lyle, the motion to withdraw alleges that over the course of 35 years of incarceration, Lyle violated prison rules 19 times, not 5. Yet again, the district attorney does not discuss what these additional violations are or when they occurred. Yet again, for good reason. Of the additional 14 violations, 12 were counseling chronos only, the most recent of which was 15 years ago. Okay. These 12 chronos included such violations as refusing to turn on a light in his cell, excessive contact with a female visitor, arms around waist and or shoulders and head on shoulder, and an attempt to get new sneakers. The most recent of these 12 chronos was 15 years ago. Both of the remaining two violations were administrative RVRs only and nearly 30 years old. One, a 1996 violation for refusing to leave his cell, and two, a 1997 violation for circumventing mail procedures and enabling other inmates to purchase certain clothing. As with Erik, the district attorney's original decision was not to include such outdated and inconsequential violations in the resentencing calculus was sound. So they didn't include them because they're so outdated. They don't have a whole lot of consequence to what's going on here. We're talking about rehabilitation, not 20, 15-year-old violations that didn't amount to anything. No punishment, no nothing, no findings. So this is ridiculous. All right, we're wrapping it up here. In summary, in his declaration, Mr. Subia makes clear that in order to protect staff, an inmate's dangerousness is among the most important considerations in running a prison. Rule violations that do not rise to the level of an RVR are generally considered irrelevant to the inmate's constitutional security or risk to public safety. Courts agree, as noted above, an inmate's rule violations support denial of parole only if they are rationally indicative of the inmate's current dangerousness. Here, as to Erik, the new district attorney identified 5 additional violations over 35 years, the most recent of which was more than 2 decades ago. As to Lyle, he identifies 14 violations, the most recent of which was 15 years ago. Equally important, the case law makes clear that to be relevant as a factor in the resentencing calculus, the rule violations must be rationally indicative of the inmate's current dangerousness. And the new district attorney never explains how Erik's 1997 possession of a floppy disk with personal letters on it, his 1997 improper kissing of his fiancée, or his 2005 talking too long on the telephone show that he is currently dangerous. How are any of those things relevant? Nor does the district attorney explain how violations like Lyle's 1996 refusal to turn on his cell light, his 2003 excessive contact with a female visitor, his arms were around a waist and or shoulders and head on shoulder, or his 2010 attempt to get new sneakers show that he is currently dangerous. In short, the district attorney has succeeded in identifying minor rule violations, most of them decades old, which the authors of the original resentencing request elected not to reference. None of those outdated and minor violations rationally indicate current dangerousness, and none present an even remotely legitimate justification to prevent or to permit withdrawal of the original request for resentencing. In its motion to withdraw, the new district attorney properly recognizes that on November 25th, the court indicated that it would proceed on its own motion uh, for resentencing if the people were permitted to withdraw their request for resentencing. The district attorney has indicated the state is ready to proceed on this alternative basis, and that was signed by Cliff Gardner, Mark Garagos, Alexandra Kazarian, sorry, Michael Romano, blah, 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 I can talk, and Melina Blake. That's a name I have not seen before. All right, we're going to go through some of these exhibits. We're not going to go through all of them. I'm going to just briefly show you a few. I am going to put a link below to this document so you can read through them more thoroughly if you want to. Because, for instance, like the Gavin Newsom's denial of Sirhan, however you say it, his testimony or his parole his was denied by the governor. So that whole decision is in here. I'm not going to read through all of it, but we will at least read through some bits of it. So, all right. So the first exhibit is this is basically just a transcript of an interview that was done with that KL. What is it? I'm missing. I can't see the screen. KTLA. KTLA News Morning Channel 5. So this is the transcript. We're not going to read through it, but this is all the things that they talk about, all the times that he says, I'm going to do the hard work. That's where these are where he's quoting from. So he's giving the sites for all of these different ones. So that was exhibit 1. Next is exhibit B. We are actually going to read through this one. So that, or no, not this one, but we'll read through the next one. Sorry. Actually, yeah, let's read through this one. So this is short. So Nancy Theberge, this is her notice of interdepartmental transfer. This is a letter sent to her on December 10th, 2024, delivered first class mail. That's all. All right, so thank you for your dedicated service to the County of Los Angeles and the Office of District Attorney, where you have been where you've been working ever since November 16th, 20, why do I keep saying 19? 2021. Sorry. I got a bad itch. My eye. So she's been working there since 2021. Pursuant to civil service rules, assignment, interdepartmental transfer, and change of classification, you are hereby further informed in writing about interdepartmental transfer to the Los Angeles County Alternate Public Defender. Okay. Your start date with the ADP will be on Friday, December 20th. So 10 days from now. This transfer was previously discussed with you on Friday, December 6th. Your newly assigned position of deputy APD is of the same grade and rank as that of the deputy district attorney that she is now, and it is similar to the prior held item before you transferred to the DA when you were a deputy public defender. You are ordered to report on Friday, December 20th to the ADP as follows, and they give some contact information. Please note that you must return your DA identification badge and all other county properties, keys, electronic equipment, computers issued to you by the department no later than the close of business on Friday. You are requested to return these items to the following location, and they give an address there. Failure to return your ID badge and/or other county properties will compel the department to initiate appropriate action to recover them. some statute affords an employee the opportunity to appeal an assignment, interdepartmental transfer, or change in classification to the director or of personnel. Further, you should be aware that an appeal should not authorize the employee to refuse the assignment, transfer, or change in classification pending completion of the appeal process. All right, so she can appeal it, and this was sent by Lisa M. Garrett, Director of Personnel. Next item is a tort. So this is uh, basically there's Brock Lunsford and Nancy Theberge are both suing the LA County DA's office because of what they did, because they were demoted. Basically, uh, it was due to retaliation. So there's an identical one in this document for Brock Lunsford, but his name is in the document instead of Nancy. All right, so to whom it may concern, please be advised that my office has been retained to present Nancy Theberge in connection with her employment with the County of Los Angeles and the Los Angeles District Attorney's Office, collectively entity defendants. By this letter, we present the following claim for damages on her behalf in what is commonly referred to as a tort claim form. Individuals and entities against whom claims are brought. The names of the public entities and public employees who caused Theberge injuries include but are not limited to the County of Los Angeles, the LA District Attorney's Office, Nathan Hochman, and John Lewin. So whoops, that's not where I wanted to highlight. All four are, I believe, named in the tort. Nancy Theberge, a 56-year-old female, began her career with entity defendants in November 2021. Over the course of her tenure, Theberge demonstrated professionalism and dedication to the administration of justice. Despite her commitment to her role, Theberge became a target of unlawful discrimination based on her age and gender. Theberge was also targeted because of her perceived political association with George Gascon, the current district attorney, Nathan Hochman's political opponent, and because of her internal and external reports on compliance with Penal Code Section 1172.1 by the County of Los Angeles and the Los Angeles District Attorney's Office. Theberge's exemplary employment. So she has a number of reasons why she feels she was targeted. It's not just her association with Gascon, but that's one of them. Theberge's most recent assignment with entity defendant was post-conviction litigation and discovery. Theberge was an exemplary employee throughout her employment with entity defendants. Theberge's most recent performance evaluation, given in October of 2024, stated that she exceeded expectations in 7 categories and met expectations in 4 categories. Throughout her employment, Theberge never received a poor performance review. Theberge was a supervisor with entity defendants and was noted for her high level of professionalism and high level of professional skills. Theberge's political affiliation. Theberge openly supported George Gascon as district attorney and his re-election for the same office. Theberge supported and attempted to carry out, to the best of her ability, every lawful policy adopted by Gascon. Discrimination and retaliation. Theberge was subjected to discriminatory treatment within the district attorney's office due to her age and gender. Leadership in the office treated Theberge differently from younger male colleagues, undermining her authority and professional standing. That would be so irritating. Advocacy for resentencing under Penal Code Section 1172.1. California Penal Code Section 1172.1 passed into law in 2022. The law allows a criminal defendant to be resentenced if, among other factors, continued incarceration is no longer in the interest of justice. As explained further below, Theberge reported both internally to entity defendants and externally to the California courts that Erik and Lyle Menendez should be resentenced because their incarceration is no longer in the interest of justice, and that to recommend against resentencing would be a violation of Penal Code 1172.1. So it's a violation of this penal code to recommend against it. So she was just following the law. So starting in the beginning of October 2024, the Burge attended meetings of the executive team concerning the motion for resentencing. Present at these meetings were Brock Lunsford, Nancy TheBurge, George Gascon, the district attorney at the time, Joseph Iniguez, I don't know if I'm saying that right, Gascon's deputy, head deputy Lori Deary, the Burge's supervisor, director Stephanie Pearl-Meyer, and assistant deputy DA James Garrison. The Burge stated during these October 2024 meetings that failure to advocate resentencing would violate Penal Code Section 1172.1, while Gascon and Iniguez supported Lunsford's position. Lori Deary and James Garrison appeared displeased and said that they disagreed with Lunsford and the Burge uh, played said they disagreed with Lunsford and Burge played a pivotal role in the primary author in October 2024 of a motion filed in Los Angeles Superior Court advocating for their resentencing. This memorandum, co-authored with Brock Lunsford, articulated the legal procedural basis for resentencing. The Burge's position, based solely on her interpretation of the law, was met with resistance from the new leadership within the district attorney's office. So again, she made her position based on the law. She got pushback from other people in the office who seemed less supportive of Gascon and more supportive of Hochman, apparently. Retaliation for the Burge's protected classes and activity. The district attorney's office retaliated against the Burge for at least three unlawful reasons. Her report to George Gascon, the district attorney at the time, George Iniguez, Gascon's deputy, head deputy Lori Deary, the Burge's supervisor, director Stephanie Pearl-Meyer, and assistant deputy DA James Garrison in October 2024, and her motion to the Superior Court for the resentencing of Erik and Lyle Menendez under Penal Code Section 1172.1, and her internal and external reports that would be a violation of the statute if a contrary position was taken. 2. Nathan Hochman's belief that the Burge supported his political opponent, a violation of civil service rules in California statutes prohibiting political discrimination. This belief includes, but is not limited to, the Burge's October 2024 motion for resentencing. Number 3, her age and gender and her opposition to gender and age discrimination. In response to the Burge's internal and external reports on violations of the law, the district attorney's office transferred the Burge out of her position entirely, reassigning her to the alternative public defender's office. The Burge's assignment became effective December 19, 2024. In her new role, the Burge was placed at the bottom of the organizational hierarchy, a clear demotion that diminished her professional standing and opportunities for advancement. The Burge was treated worse than her male colleagues in that she was transferred out of the district attorney's office entirely. John Lewin, the other person that was named in the suit. John Lewin is and was a deputy district attorney employed by entity defendants, and Lewin, while acting within the course and scope of his employment with the district attorney's office, defamed the Burge. Lewin and Hochman acted in concert. Interesting. Hochman either authorized Lewin's conduct and or ratified it. On September 28, 2024, Hochman's website publicly listed John Lewin as a supporter and praised Lewin for standing up to be individually counted. So for uh, because it's right around election time. On or around October 26th, Lewin defamed the barge by publicly stating that she had breached her duty of candor to the court in connection with the motion for the resentencing of Erik and Lyle Menendez. This baseless and inflammatory accusation falsely suggested that the barge acted unethically and in violation of her professional responsibilities. Lewin further stated that the barge was incompetent in her profession. These statements include, but are not limited to, the statements that the barge had no interest in justice, wanted to let criminals out of jail, and was dishonest in her filings with the court. The charge of dis- the charge of dishonesty to the court is a statement of fact that the barge violated the ethics of her professional and responsibility as an officer of the court. I think we're missing some words there, but that's okay. On or around November 27th, 2024, Lewin publicly stated that the Burge had no interest in prosecuting criminals and stating that she had sold her soul for a few extra nickels. Wow. On more than one occasion, Lewin's defamatory statements caused significant harm to the barge's reputation as an attorney, implying dishonesty and a lack of integrity in her legal work. Further, after Lewin defamed the barge, Huckman promoted Lewin and gave him a promotion in major crimes. This effectively ratified his defamatory conduct, further compounding the harm to the barge's professional standing, the harm to the barge's career and reputation. As a result of the discrimination, retaliation, and defamation she endured, the Burge's career has been severely damaged. Her transfer to a subordinate position out of the district attorney's office and to the alternative public defender's office represents a clear demotion, stripping her of the responsibilities and professional stature that she held within the district attorney's office. Additionally, Lewin's defamatory statements have caused lasting harm to the Burge's reputation in the legal community, undermining her credibility and professional prospects. The Burge was coerced to republish defendant's defamatory statement to colleagues and family to refute the allegations and protect his professional reputation. Potential legal theories and claims. The Burge anticipates bringing causes of action based on the following legal violations and theories. 1. Discrimination and harassment on the basis of gender and age. Retaliation, including retaliation for complaining about discrimination or harassment. Failure to prevent discrimination, harassment, or retaliation. Violation of the California Labor Code, violation of labor code sections, more codes, negligent infliction of emotional distress and intentional infliction of emotional distress, negligent hiring, supervision, and retention. Additional causes of action and or theories of relief may be raised on the basis of the facts generally set forth above, as is permitted by Blair versus Superior Court. Damn, that's a lot of stuff that she's calling them out on. This is currently happening in like in real time. Damages sought. The Burge seeks economic damages of over $250,000 and non-economic damages in the amount of over $5 million for damages in total of over $5 million. The Burge also seeks interest, attorney's fees, and costs through the amounts of such interest, fees, and costs are not known at this time. The proper jurisdiction for litigation in this matter in Los Angeles County Superior Court are an unlimited case. The Burge's address is redacted. Our client requests that all notices be sent to her legal counsel, and there's their information acting on our client's behalf and signed. So there you have it. That is Nancy Burge's claims against the current DA and the office there and John Lewin. This next Exhibit D is a copy of this article from Deadline, which was also referenced in the defense's motion here. It's rather long. I'm not going to read it, but this is where he says that the brothers' lawyers' narrative is absolutely wrong. And he's like saying, that they're, um, that the lawyers are lying and the brothers are lying and everyone in the world is lying except the DA's office. So I'm not going to get into it, but you can read it on your own. The next document is it's an article that it was referenced in the motion about the retaliation that is going on in the office. So there's more people that are, suing about fear of retaliation. This is going on since 2019. So this woman here alleges that District Attorney Jackie Lacey, obviously a different district attorney, has protected sexual harassers in the office and retaliated against victims and whistleblowers who speak out. So this has been an ongoing situation. And there's more to the story. Obviously, I'm not going to get into all of it, but here it also says that several deputy district attorneys who asked not to be identified to avoid retaliation claimed whistleblowers who file complaints often are denied promotions, banished to far flung offices in what is known as freeway therapy. That's the term that was used in the motion, stripped of important cases, or relegated to mundane, demoralizing duties. They also complain that some prosecutors accused of sexual harassment have been allowed to keep their jobs or permitted to retire with hefty pensions. That's sick and gross. The next exhibit here is the announcement that Kathleen Cady was named the director of the department's Bureau of Victim Services right after Nathan Hochman took office. So he appointed her. This is the Sirhan parole decision. So let's go through just a little bit. Statement of facts. On June 5th, 1968, Senator Robert F. Kennedy, a candidate for President of the United States, was in Los Angeles for the California Democratic presidential primary election. That evening, Senator Kennedy was declared the winner of the election and celebrated with a large crowd of supporters at the Ambassador Hotel. While Senator Kennedy greeted hotel staff, Sirhan shot him at close range. Mr. Sirhan also shot 5 bystanders: Elizabeth Evans, Ira Goldstein, Paul Schrade, Iron Stoll, and William Weasel. That's an unfortunate last name. All of whom survived their injuries, but Senator Kennedy did not. Mr. Sirhan was convicted by a jury of first-degree M-word and 5 counts of assault with a deadly weapon with intent to commit homicide. On May 22nd, 1969, he was condemned to death. In 1972, following a change in California law, Mr. Sirhan's sentence was modified to life in prison with the possibility of parole. In 1975, the Board of Parole Hearings found Mr. Sirhan suitable for parole, but then the board rescinded his parole grant. The board then conducted 15 subsequent hearings and at each one found Mr. Sirhan unsuitable for parole, but in August of 2021, the board conducted their 16th hearing and found him suitable for parole. So this is where it gets to Governor Newsom. He now gets it in front of him and he gets to decide if, the board is saying we recommend him for parole, and now the governor gets to look at that and say, well, wait a minute, let's evaluate this and do I agree? So here's his statements. First up, he says, governing law, he has discretion. He's given broad discretion to determine an inmate's suitability for parole and may affirm, reverse, modify, or refer back to the board any grant of parole to a person convicted of homicide serving an indeterminate life sentence. So basically stating he has authority to rescind it if he wants. So we're going to skip through the rest of that, but I'll read through some of the decision here. Mr. Sirhan's assassination of Senator Kennedy is among the most notorious crimes in American history. Senator Kennedy's homicide caused his family immeasurable suffering, including his pregnant wife, their 10 children, and the extended Kennedy family. Mr. Sirhan shot Senator Kennedy in front of news cameras, which subjected the Kennedy family and American public to a ubiquitous video loop of Senator Kennedy's violent death and his wife's anguish at his side. Mr. Sirhan's crimes also caused great harm to the American people. Senator Kennedy's assassination upended the 1968 presidential election, leaving millions leaving millions in the United States and beyond mourning the promise of his candidacy. Compounding the grief of the Kennedy family and the American public, Mr. Sirhan killed Senator Kennedy during a dark season of political assassinations just 9 weeks after Dr. Martin Luther King Jr.'s homicide and 4.5 years after the homicide of Senator Kennedy's brother, President John F. Kennedy. It's such a horrific tragedy for that family. The gravity of Mr. Sirhan's crimes alone counsels against his release, but I have concluded that he is unsuitable for parole because he poses a current threat to public safety. All right. Well, let's break it down. Let's find out why. Because that's the big thing as to, he keeps comparing Sirhan to the Menendez brothers, but he doesn't really talk about the dangerousness aspect of it, Hawkman, in his 88-page garbage motion. So after decades in prison, Mr. Sirhan has failed to address the deficiencies that led him to assassinate Senator Kennedy. Mr. Sirhan lacks the insight that would prevent him from making the same types of dangerous decisions he made in the past. The most glaring evidence of Mr. Sirhan's deficient insight is his shifting narrative about his assassination of Senator Kennedy and his current refusal to accept responsibility of his crimes. The evidence that Mr. Sirhan shot and took Senator Kennedy's life in an act of premeditated homicide is overwhelming and irrefutable, and the claims of innocence by Mr. Sirhan and his advocates have been investigated and conclusively disproved. As the following examples show, Mr. Sirhan has inconsistently described his role in the assassination of Senator Kennedy, claimed his shifting memory lapses, minimized his participation in the crimes, and outright denied his guilt. The Menendez brothers have never done that. While in police custody, after his arrest in June 1968, Mr. Sirhan admitted that he assassinated Senator Kennedy in a recorded statement. At his trial, which began in February 1969, Mr. Sirhan testified that he shot Senator Kennedy but was drunk and could not remember his actions. Later during his trial, when the jury was not present, Mr. Sirhan exclaimed, "I took Robert Kennedy's life willfully, premeditatively, with 20 years of malice aforethought." He later said that he made this statement to get attention. Mr. Sirhan told the board's psychologist, who evaluated him in 1972, that he really didn't want to commit homicide when he shot Senator Kennedy, but I merely wanted to attract attention to the plight of his fellow countrymen. I really do feel like this guy was MK Ultra to some extent. At his 1979 parole hearing, Mr. Sirhan told the board that he was drunk at the time of his crimes. He said, "I don't feel myself to be responsible beyond the first shot." So he's responsible for the first one, but not the others. Okay. At his 1985 parole hearing, Mr. Sirhan admitted to writing entries in his journals found by police in his bedroom after the crimes that repeated RFK must die, RFK must be killed, Robert F. Kennedy must be assassinated, and Robert F. Kennedy must be assassinated before the 5th of June, 68. And June 5th, 1968, was the 1 year anniversary of the beginning of the Arab Israeli Six-Day Wars, as well as the date of the California primary for the 1968 United States presidential election. There was a lot going on at the time. Where did I get that footnote from now? I can't find it. Oh, up here. Okay, so he wrote, "My determination to eliminate RFK is becoming more of a unshakable obsession." At the same 1985 parole hearing, Mr. Suran stated that liquor was the main culprit for his crime. So he has just been all over the place as to why he did it and what he remembers and how he is responsible, if at all. At his 1987 parole hearing, Mr. Surin admitted that he shot Senator Kennedy but denied shooting the other victims. He said that he committed the crimes in retaliation for Senator Kennedy's statements of support for the United States military aid to Israel. At the same time, Mr. Surin claimed that his memories were vague. He told the board that he suspected he had blocked the shooting from his memory for his self preservation. In 1989, Mr. Surin told a reporter during a televised interview that he committed the assassination because Mr. Sirhan objected to Senator Kennedy's support for Israel. Mr. Sirhan said, "When he assassinated Senator Kennedy, he extinguished a great star, a champion of all mankind, and it's hard for me to live with the experience myself, but I'm a human being and I have to adjust and carry on with my life. I never dreamed of ever offending the American system of government or frustrating the votes and the hopes of millions of Americans, and having done so, sir, I can't say anything but that I apologize for having done that." Later in 1989, at his parole hearing, Mr. Surin told the board that he could not remember the details of the crimes. In 1990, Mr. Sirhan told the parole hearing that he derived his knowledge about the facts of the assassination from accounts of the crimes that he had read, and that while he remembered being at the Ambassador Hotel, he had no memories of taking Senator Kennedy's life. In 1997, Mr. Sirhan began reporting his belief that he did not commit the crimes and was innocent. So now he shifts gears. In 2001, during a forensic evaluation, Mr. Suran said he felt distant from responsibility and guilt and that he doubted that he committed the crimes. At his 2011 parole hearing, Mr. Sirhan stated that he could recall being at the Ambassador Hotel but not using his gun. At his 2016 parole hearing, remember he had 16 of them, in his 2016 parole hearing, Mr. Suran said he did not remember the details of the crimes, but believed that he was innocent because of what he had read about the case in his attorney's briefs. He told the board, "Legally speaking, I'm not guilty of anything." In 2021, Mr. Suran told the board psychologist that he was innocent of the crimes and was in the wrong spot at the wrong time, portraying himself as a victim. Now he's a victim. The deficiencies in Mr. Sirhan's insight and his failure to accept responsibility for his crimes are well documented beyond his own statements. In 2021, the board psychologist who evaluated Mr. Sirhan reported that Mr. Sirhan denied planning the crime and denied remembering committing any illegal act on the right in question. The psychologist noted despite multiple attempts, Mr. Suran would not report his understanding of the facts of the crime, as he instead referenced others' reports. The psychologist observed that Mr. Sirhan reported significant memory impairments that were only present when Mr. Sirhan was discussing his history of engaging in antisocial and violent actions. While the psychologist found that Mr. Sirhan's current cognitive abilities appear grossly intact, Mr. Sirhan answers were evasive. He appeared to be engaging in significant impression management, and overall, he was not believed to be a reliable source of information. Mr. Sirhan's implausible and unsupported denials of responsibility and lack of credibility elevate his current risk level. They indicate that Mr. Surin, despite decades of incarceration and purported efforts in rehabilitation, has failed to address the deficiencies that led him to assassinate Senator Kennedy. The record further demonstrates that Mr. Surin has not meaningfully disclaimed political violence committed by him or in his name, nor shown that he appreciates the unique risks created by his commission of a political assassination. These gaps in Mr. Surin's insight have a close nexus to his current risk of inciting further political violence. So his whole insight of not understanding is about his, what he did on a national level. What he did affected an entire world, a nation that, was looking for hope. And then by doing what he did, he crushed that hope for America, which also crushes hope for a lot of the rest of the world when that happens. So he failed to accept that responsibility. I think that's pretty, that's something that he should be accountable for. The fact that he, hurt the country so badly. Mr. Surin's prior discussion of his crimes and connections to political violence illustrate the extent of his current threat to public safety. In 1973, for example, in an effort to secure Mr. Surin's release from prison, terrorists took 10 hostages, 3 of whom were um, also, their lives had been taken. They were unalived when the terrorists' demands were not met. So, 3 terrorist groups seized the Saudi embassy in Sudan, capturing 10 hostages, including a U.S. ambassador the U.S. ambassador to Sudan, Cleo A. Noel, the Saudi Arabian ambassador to Sudan, Sheikh Abdullah and Al Malhaq. Sorry, I am probably butchering these names, and his wife and children, the American charge of affairs, the person like in charge of affairs, George Curtis Moore, the Jordanian person in charge of okay, so all of these people were hostages. The terrorists demanded the release of Mr. Sirhan and other prisoners. So the terrorists demanded the release of Mr. Sirhan. When negotiations failed, the hostage takers assassinated 3 of those individuals listed. That was Moore, Mr. Eid, and Ambassador Knoll. All right, so following, did I read that? Yeah, following his parole denial in 1987, Mr. Sirhan twice invoked this incident, stating that the terrorists took hostages on his behalf and were helping him to escape from prison. In 2021, when the evaluating psychologist asked Mr. Surin about the assistance he received from terrorists, Mr. Surin laughingly dismissed the incident. He neither claimed the violence committed in his name nor I'm sorry, he neither disclaimed the violence committed in his name nor renounced his prior acceptance of assistance from those terrorist groups. Although these events occurred decades ago, Mr. Sirhan's inability to appreciate their current relevance reveals glaring gaps in insight. So this is all stuff that's like still relevant to his rehabilitation, whereas the things that Nathan Hawkman brought up, nothing was relevant to rehabilitation. Not a single thing. Mr. Sirhan further demonstrated his deficient insight at his 2021 parole hearing when a commissioner suggested that Mr. Sirhan would be naive not to expect public attention upon his release and calls for him to express his views on the Israeli Palestinian conflict. Mr. Sirhan remarkably replied that he found that hard to foresee. The commissioner questioned Mr. Sirhan about the possibility of being used as a lightning rod foment to foment violence, whatever that word means, um, to promote violence, to make violent, is he going to be a beacon of, people wanting to commit more violence? Mr. Sirhan rejected this possibility out of hand and implausibly suggested that it was equally likely that he could be used as a peacemaker and a contributor to a friendly, nonviolent way of resolving the issues. The board found his professed intention not to be a rebel or a troublemaker sufficient to mitigate this risk factor. I disagree. Not only has Mr. Sirhan failed to meaningfully disclaim political violence, he lacks the skills required to control his response to external triggers, which are critical for mitigating the public safety risks that he poses. So that's important too because Eric and Lyle have not been violent. They don't get, they don't like lash out in anger and whatever. Like there's no instances of that in prison. Like for all we know, they're very, calm, good to get along with guys that happy not happy go lucky, but as happy go lucky as you can be in prison. And they're focused on what they're doing and that's giving them purpose. So they're not sitting around and, thinking about how to make more trouble or whatever Saran was doing. So at his 2021 parole hearing, for example, the board asked Mr. Saran to describe his internal mental processes for dealing with stressors. Mr. Saran's answers demonstrated that he does not understand these processes or their steps from self-awareness to effective self-control. Despite his incomplete answers to these questions, the board found that Sirhan's anger management skills are sufficient to manage the public safety challenges he would face on parole. Here, too, I disagree. And this is another key thing, too, because we know Eric, and at least Eric, um, does meditation. He teaches meditation, he practices it, he's become very into meditation. And meditation makes you 10 times calmer than you normally are, maybe even more. And it gives you, it helps you become aware of your emotions and it helps you control your emotions. You don't react so quickly to anger and things like that. So if Eric's doing meditation and teaching meditation, I don't believe that he's having this problem where he just reacts in anger, like they're saying Mr. Sirhan has anger management issues. Whereas Eric and Lyle, we don't have any evidence that they do. Here, too, Governor Newsom disagrees. I am not persuaded that Mr. Sirhan understands the steps required to manage even quotidian interpersonal conflict. All right. Let alone the complex geopolitical hazards he must navigate in California and beyond if he is allowed to parole. Mr. Sirhan cannot be safely released because he has refused to acknowledge these risks and to develop the skills to mitigate them. Finally, I am required by law to consider the additional factors that are legally relevant to Mr. Sirhan's suitability for parole. As explained below, I have weighed these factors and conclude that they do not outweigh the substantial evidence of Mr. Sirhan's current dangerousness. First, in the case of inmates who commit their crimes when they are under 26 years old, as in Mr. Surin's case, I am required to review the record for evidence of factors relevant to their diminished culpability as youthful offenders and any subsequent growth and increased maturity. Mr. Sirhan was 24 years old when he assassinated Senator Kennedy. I have carefully examined the record for evidence of youthful offender factors. I acknowledge that at the time of his crimes, Mr. Sirhan exhibited some of the hallmark features of youth as set forth in the relevant statutes. I have also examined the record for evidence of Mr. Sirhan's subsequent growth in prison and increased maturity and rehabilitation. I acknowledge that Mr. Sirhan has made some efforts to improve himself in prison, though through self-help programming and other pro-social efforts. While Mr. Sirhan has undoubtedly matured in some ways over the last 53 years, the record evidence shows that he has not internalized his rehabilitation programming sufficiently to reduce his risk for future dangerousness. The psychologists who evaluated Mr. Sirhan in 2010, 2015, and 2020 rated him a low risk for future violence despite his deficits in insight. The psychologist who evaluated him in 2020, however, noted a concern about Mr. Sirhan's treatment responsiveness in the community because Mr. Sirhan continues to have problems with certain risk factors despite engaging in relevant programming. Consequently, even after according these youthful offender factors great weight, I conclude they are eclipsed by the strong evidence that Mr. Sirhan's current dangerousness. Second, I have given special consideration to the elderly parole factors for inmates who are older than 60 and who have served more than 25 years in prison. Mr. Sirhan is 77 years old and has served 53 years. While the psychologist who evaluated Mr. Sirhan in 2021 found that Mr. Sirhan had not had any significant problems with his advancing age, the commissioners at Mr. Sirhan's parole hearing, 2021 parole hearing, determined that he is significantly incapacitated as far as committing additional crimes. But Mr. Sirhan's risk of committing acts of interpersonal violence is not the most relevant indication of his current risk level. As explained above, Mr. Sirhan poses a risk to public safety because he lacks insight, as demonstrated by his refusal to accept responsibility for the assassination of Senator Kennedy, his failure to renounce political violence, and his lack of the requisite skills to manage complex external triggers. Thus, evidence of Mr. Sirhan's diminished physical strength does not mitigate the serious threat to public safety that he currently poses, including the risk that he may incite political violence should he be released. I mean, what's stopping him from assassinating somebody else if he gets out? He may be 77 years old, but it doesn't take a whole lot of strength to pull a trigger. Accordingly, his release is not consistent with public safety. Conclusion: when considered as a whole, I find the evidence in the record demonstrates that Mr. Sirhan currently poses an unreasonable danger to society if released from prison. Despite his 53 years of incarceration, Mr. Sirhan has failed to develop the insight necessary to mitigate his current dangerousness and is unsuitable for parole. Consequently, I reserve the board's decision to parole Mr. Sirhan. That was January 13th, 2022, when Gavin Newsom did that. All right, so our next exhibit is a declaration from Richard Subia, who is an employee of the California Department of Corrections and Rehabilitation. He was a corrections officer starting in 1986, held many positions up until lieutenant, warden, eventually director of the division, until he retired. By the end of his career, he was responsible for administering operation of over 162,000 inmates in all 33 California adult prisons and other facilities. So he knows what he's talking about. He was responsible for the management of over 20,000 employees. All right, so he's going to go into the different kinds of violations. So this is the backup for what the motion was talking about regarding the different kinds of violations, the levels of violations, how they count against you, and whatnot. So I'm going to kind of scroll down here to serious violations. Um, Actually, go here. Prisoner conduct is governed by the California Code of Regulations, Title 15, and generally falls into three categories: serious rule violations, also known as rule violation reports, RVs or 115s, administrative misconduct, and counseling chronos. Serious rule violations, or RVs, are defined in California Code of Regulations, Title 15. An inmate who is found guilty of a serious rule violation will forfeit credits against his or her release date, may be placed in a security housing unit, or the SHU, will have points added to their classification score, and may be referred to the district attorney for criminal prosecution depending on the seriousness of the violation. Serious rule violations are sometimes referred to as 115s because those are the violations, that's the form that they're documented on. Serious rule violations range in degrees of seriousness and are categorized as divisions ranging from Division A1 to Division F by the California Code of Regulations, Title 15, and same section. We're not going to read all of that. All right, so the most serious rule violations are categorized as Division A1 offenses and result in credit forfeiture of 181 to 360 days, extended placement in SHU, and frequently trigger criminal prosecution. These violations include acts of, taking a life in prison, Ring someone in prison, trying to escape. The least serious rule violations are categorized as Division F offenses and result in credit forfeiture of 0 to 30 days. These violations include gambling, refusal to perform assigned work duties, or misuse or alteration of state property. Administration misconduct is defined in California Code of Regulations, Title 15, Section 3314. Although administrative misconduct is also reported in the RVR, administrative misconduct reflects less serious violations of CDCR rules and cannot result in credit forfeiture, SHU placement, or points added to the inmate's classification score. An inmate found guilty of administrative misconduct may result in loss of privileges, including access to yard time or other activities. Examples of administrative misconduct are missing a work assignment, using vulgar language, and the failure to comply with grooming standards. The third and least serious category of misconduct is reflected in counseling chronos. Counseling chronos are sometimes referred to as 128s because those are the documents they use. A counseling chrono is used to record any misconduct that does not amount to a serious rule violation or an administrative misconduct. The chrono merely records that this behavior was observed and reported to the inmate. There are no disciplinary consequences from a counseling chrono. Examples of misconduct warranting a counseling chrono include taking too much food from the cafeteria, taking too long to shower, or altering your prison garments. An inmate's overall disciplinary record is tabulated in the inmate's classification score, which is governed by California Code of Regulations, Title 15, Section 3375. Classification scores are used to measure an inmate's institutional behavior over time and generally determine an inmate's housing placement, necessary level of security, and eligibility of programs, classes, and other privileges. Points are added to an inmate's classification score for serious rule violations, depending on the severity of violation, and points are subtracted from a classification score for extended periods of rule compliance. So a lower classification score reflects better institutional behavior. So those low classification scores of Lyle and Erik mean that they have been in compliance for many, many, many years. It's been extended periods of time that they have built their score all the way down to 0. They've knocked off all those points from, previous violations back in the 90s, which is where Nathan Hockman's brain is stuck. Because misconduct that does not arise to a serious rule violation is not calculated as part of an inmate's classification score, such conduct is generally considered irrelevant to the inmate's institutional security or risk to public safety. As a correctional officer, warden, and director of the Division of Adult Institutions, I was aware of inmate misconduct that did not amount to a serious rule violation, but this conduct carried minimal weight in inmates' housing placement, programming placement, risk to institutional or public safety, or suitability for release. This was the general approach taken by my colleagues throughout CDCR. I have been advised that in the November 2024 motion request to recall the sentence, the Los Angeles District Attorney reported that 1. Erik Menendez's prison file showed 8 RVRs, and 2. Lyle's prison file showed 5 RVRs. I have also been advised that in a March 2025 filing, the District Attorney notes that Erik has been cited at least 13 times for violating prison rules, and Lyle has been cited for violating the rules 19 times. As the above discussion makes clear, there is substantial difference between an RVR and any violation of prison rules, and even RVRs range in seriousness as delineated by division level. For obvious reasons, in order to protect staff, an inmate's dangerousness is among the most important considerations in running a prison. Yet, as noted above, rules violations do not rise to the level of an RVR. Rule violations that do not arise to the level of an RVR are generally considered irrelevant. So if it doesn't get to the point of an RVR, so if it's administrative or a chrono, neither one of them are relevant to a defendant's or an inmate's suitability for parole. In addition, I have been advised that in his 2025 March filing, the district attorney asserts that Erik Menendez suffered a rules violation for assaulting a female visitor in 1999. This is incorrect. I have reviewed Erik's prison central file and the relevant documents related to this incident. In fact, the rules violation is not contained in the official prison record, which indicates that it was reversed. So you flat out lied or didn't do your homework in your motion. As July 7th, 1999 memo states that the allegation that Erik assaulted a visitor was unsubstantiated. The dismissal of the violation is confirmed because Erik's file reflects that he suffered no consequences or credits loss in retaliation or in relation to the incident. If the violation was sustained, his file would reflect lost credits. So he doesn't have any lost credits. It's been basically dismissed. It's been removed, reversed. Furthermore, there are no additional documents related to the incident in Erik's central file because, consistent with their practices and regulations, documents related to a violation that has been dismissed are either removed from an inmate's record or updated to reflect the dismissal. So if it's not there in his record, that means it was dismissed and therefore removed from his record. We have 2 more documents to get through. This is a much shorter video than yesterday's. This is a memo from a K. Meyer, who was actually, I believe he's a corrections officer, but I don't want to misstate what he is until we read it in full. I only skimmed it partially, but corrections officer. Didn't even see that. I skimmed not the first sentence, obviously. So he is a corrections officer and he is writing a memo in support of resentencing of the brothers, or specifically Lyle. This is for Lyle. So I am writing this letter in my capacity as a corrections officer at the R.J. Donovan Correctional Facility to support the resentencing efforts on behalf of Lyle Menendez. I supervised him for several years while in charge of the facility, the gym, where all the Green Space Project tools and materials are stored. Securing these materials is critical to the safety and security of the facility. Normally, an inmate would not be authorized to assist with this process. It was determined by the administration based on his history with the department and recommendations from staff that Mr. Menendez exhibited a rare level of trustworthiness and ability to resist negative peer pressure. A position was created allowing Mr. Menendez to work directly with staff to secure potentially dangerous work tools and materials. I found him to be honest and reliable. I want to mention something else I think is relevant to his character. My post in the facility gym uh, placed me in an environment where I was the only officer supervising a large number of inmates. The facility employs a large number of non custody, recreational, and support staff. There is a history of staff assaults in corrections. Areas that are undermanned are particularly vulnerable to these incidents. Mr. Menendez spent a lot of his time in the gym where the supply rooms are located for his work. Quite often, a disgruntled inmate would be argumentative with one of the recreational support staff members. If inmate Menendez was closer to the situation than I was, he would leave where he was and place himself physically between the disgruntled inmate and the staff member and attempt to mediate. His willingness to place himself in potential jeopardy to assist a staff member clearly shows his character and is greatly appreciated. It is also exceedingly rare in my observation. It is beyond my capacity to give any opinion about his past. However, I have had conversations over the years with Mr. Menendez in which the crime for which he is incarcerated came up. I found him to be remorseful and thoughtful about it. I remember most that he lamented the impact of his extended family, which is the victim's family. It is no surprise to me to have learned that many of the victim's families support his and his brother's resentencing. I believe Lyle Menendez is deserving of a chance to re enter society where I am confident he will be a productive member. I support the efforts to initiate resentencing for Lyle Menendez, as well as any efforts to commute his sentence so that he may be afforded an opportunity to parole. I am willing, if needed, to appear on his behalf or to provide any additional information that may be helpful. That was nice of that guy to give that give that letter to the courts. All right, this is the final document that we're going to go over. This is Brock Lunsford's tort claim against the same people, which will be the County of Los Angeles, the DA's office, Nathan Hockman, and John Lewin. So let's skip the first sentence or first two paragraphs there because it's the same. So the facts supporting his claims. Brock Lunsford began his distinguished career with the entity defendants in June 2000, dedicating over 2 decades to public service with the goal of fostering a safer and more just Los Angeles County. Rising through the ranks of the district attorney's office, Lunsford ultimately attained a supervisory position in the resentencing unit. Despite his notable career achievements, Lunsford's professional trajectory has been derailed due to retaliation and defamation stemming both from his insistence that the County of Los Angeles comply with the law and his opposition to harassment and discrimination. Lunsford's exemplary employment. Lunsford's most recent assignment with entity defendants was post-conviction litigation and discovery. Lunsford was an exemplary employee throughout his employment with entity defendants. Throughout his employment, Lunsford never received poor performance review. Lunsford's political affiliation. Lunsford openly supported George Gascon as district attorney and his re-election for the same office. Lunsford supported and attempted to carry out, to the best of her ability, every lawful policy, I think that's supposed to say his ability, the lawful policy adopted by Gascon. I believe this is probably like the same people representing him because it looks like same stationery and everything. So Lunsford's political affiliation. Lunsford openly supported, oh, sorry, I read that already. Lunsford supported and attempted to carry out, to the best of his ability, every lawful policy adopted by Gascon. Advocacy for resentencing under the Penal Code. California Penal Code was passed into law in 2022, this particular one, that allows a criminal defendant to be resentenced if, among other factors, continued incarceration is no longer in the interest of justice. As further explained below, Lunsford reported both internally to entity defendants and externally to the California courts that Erik and Lyle Menendez should be resentenced because their incarceration is no longer in the interest of justice, and that to recommend against resentencing would be a violation of the Penal Code. Lunsford, both in internal communications and court filings, expressed his belief that Erik and Lyle Menendez should be resentenced pursuant to the Penal Code. He reasonably believed that any other position would violate the statute. Starting in the beginning of October 2024, Lunsford had meetings of the executive team concerning the motion for resentencing. Present at these meetings were Lunsford, Nancy Theberge, George Gascon, the district attorney at the time. So all of these people, we read all these people before that were at these meetings. Lunsford's position, based solely on his interpretation of the law, was met with the resistance from leadership within the DA's office. So similar to what Nancy Theberge went through. His association with Nancy Theberge is coming into play here too. So, as a supervisor, Lunsford worked closely with Nancy Theberge, an attorney over 40 years old who is female. Leadership in the district attorney office undermined Theberge in ways not experienced by male or younger employees. Lunsford believed that Theberge was discriminated against because of her age and gender. Recognizing this discriminatory treatment, Lunsford took action to support her. On multiple occasions, he opposed efforts by leadership to violate the chain of command, thereby engaging in protected activity by opposing age and gender discrimination. For example, on or around October 22nd, 2024, Head Deputy Lori Deary and the Assistant Deputy DA James Garrison attempted to circumvent the chain of command, and under Nancy Theberge, Lunsford opposed and prevented this attempt, which he believed was an example of less favorable treatment towards a female and older employee. Retaliation against Lunsford. District Attorney's Office retaliated against Lunsford for at least three unlawful reasons. His report to George Gascon, the district attorney at the time, Joseph Iniguez, Gascon's deputy, head deputy Lori Deary, deputy Stephanie Perlmeyer, and the assistant deputy DA James Garrison in 2024, and his motion to the Superior Court advocacy for the resentencing of Erik and Lyle Menendez under Penal Code Section 1172.1 and his internal and external reports. Okay, so all of that same stuff, I think. Nathan Hochman's belief that Lunsford supported his political opponent, so same thing, and his association with Nancy Theberge as a female and an older employee, and his opposition to the harassment and discrimination directed at her. Following Hochman's election to district attorney, Pearl, Deary, and Garrison all supported and participated in the decision to demote Lunsford. Lunsford was stripped of all supervisory responsibilities as of December 14, 2024, He has been reassigned as a calendar attorney in Department T of the Norwalk Courthouse, a position he had held years earlier with no opportunities for promotion or advancement. This was in retaliation for the protected activities described above. In his new role, Lunsford is required to report to a less experienced attorney and must clear his schedule with other attorneys, a stark demotion from his prior ability to set his own schedule. John Lewin was at all times relevant, acting as the agent of Nathan Hawkman. So, I guess this is different. Okay, so John Lewin is and was a deputy district attorney employed by entity defendants. Lewin, while acting within the course and scope of his employment with the district attorney's office, defamed Thurburge. Lewin and Hawkman acted in concert. Hawkman either authorized it or ratified it. Hawkman's website publicly listed John Lewin in September last year as a supporter and praised him for standing up. On or around November 27th, 2024, while acting within the course and scope of his employment with the district attorney's office, John Lewin defamed Lunsford by publicly referring to him as a quisling. Okay, so John Lewin defamed Lunsford he defamed Lunsford too, not just the Burge, but also Lunsford. So he called him a quisling, whatever that is, which means a Nazi collaborator. Oh, this statement is offensive on its face and has caused significant harm to Lunsford's professional reputation by imputing malice and incompetence to him. Lewin's statement stated outright that Lunsford is incompetent in his profession. Hawkman, after Lewin defamed Lunsford, promoted Lewin, effectively ratifying this defamatory conduct by promoting Lewin to a position with major crimes. Lunsford was coerced to publish defamatory statements to colleagues and family in order to refute the allegations and protect his professional reputation. So same things here. So his harm as a direct result of the retaliation and defamation, Lunsford's career has been irreparably harmed. He has been relegated to a position with no potential for advancement. His professional standing has been undermined, and his reputation has been damaged by the baseless and inflammatory statements of a colleague. Potential legal theories and claims. Lunsford anticipates bringing causes of action based on the following legal violations and theories: associational discrimination and harassment on the basis of gender and age, retaliation, including retaliation for complaining about discrimination or harassment, failure to prevent discrimination, harassment, or retaliation, violation of California Labor Code, violation of more labor codes, uh, violation of defamation, coerced self-defamation, negligent infliction of emotional distress, intentional infliction of emotional distress, negligent hiring, supervision, and retention, additional causes of action as they see fit. Damages sought, same thing, a little over $1 million. Lunsford wants his stuff sent to the same attorneys here, and then it's signed by his attorneys. So there you have it. That is the almost full and complete 88 pages. We skipped some of the articles because really it's not that important to me to read through all of Hawkman's BS, because we just read through 88 pages of his BS that he filed in a court. So we don't need to hear his press tour because frankly it makes me nauseous to listen to him. So does Nathan Hawkman make you nauseous? Let me know. I should do a poll. But he does. Listening to him kind of makes me not want to listen. So I didn't want to make you guys have to do that. Even if it's me reading his words, I still don't want to listen to his words. So, anyways, that is the defendant's response to Nathan Hawkman and his office's request to rescind the resentencing to withdraw it. But as we know, it's denied, so that's a good thing. Um, the next uh, the next episode we're going to have is the people's response to this document. So be prepared for that. It's a lot shorter. I think it's only like 16 pages. And then the family's request for Nathan Hochman and the DA's office to follow the law, which is Marcy's law, the victim's law. So we'll read through that too, which I think it's only like 7 or 8 pages. So that one's going to be a short video, but I want to keep them separate. So we will do them all separately, and I will see you guys in the next one. Please make sure that you hit the like button on your way out. Let me know what you think, and I will see you guys in the next one. Take care. Bye now.